For many people, the prospect of filing for bankruptcy can be scary. You might be worried about having to complete a lot of paperwork and going through complex legal procedures. I am here to tell you that you don't need to worry. Legal Helpers is the largest bankruptcy firm in the country, and we have helped thousands and thousands of people file for bankruptcy successfully. I'm now going to walk you through the steps necessary to file for bankruptcy. First, what do I have to do before filing my bankruptcy petition? Before filing your petition, you must meet with a legal helper's attorney and provide the necessary information for completion of the bankruptcy petition and schedules, including a list of your current personal property and its value, a list of creditors whom you owe, information on employment or other income, and other information that your bankruptcy lawyer will ask you to provide. Complete a U.S. trustee-approved credit counseling briefing, and give the completion certificate to your attorney to file with your petition. This can be done via phone or internet, and legal helpers will assist you through this process. After you have completed these tasks, our attorney will file the petition and credit counseling certificate with the bankruptcy court. Second, what happens after I file my bankruptcy petition? When we file your bankruptcy petition, this is what will happen. You will be granted an automatic stay from the court, which will prevent creditors from taking or continuing any collection or legal action against you. Your creditors will be sent a notice of your case being filed. A bankruptcy trustee will be assigned to oversee your case. The trustee is a federal employee appointed by the court to monitor your case and make sure you are eligible for bankruptcy. The trustee will review your petition, make sure that it is complete, and then schedule a 341 meeting of your creditors. What happens at the 341 meeting of creditors? The meeting of creditors, sometimes called the 341 meeting after the section of the bankruptcy code that describes it, is a meeting held with your bankruptcy trustee and your creditors around 6 weeks from the date when your attorney filed your bankruptcy petition. Approximately 15 days after filing, the court will mail a notice of commencement of case to you and all creditors listed in your petition, which includes the date and time of the creditors' meeting and deadlines for creditors to make objections or file claims. You must attend the meeting, and you will be asked to testify under oath to the accuracy of the information you have provided. Creditors may question you at this meeting, but most choose not to attend. At least 7 days before the meeting, you must provide the trustee and any creditor who has requested it a copy of your most recently filed tax return. Creditors have 30 days after your meeting of creditors to object to your exemption claims, and they have 60 days after the meeting in which to object to discharge of specific debts for specific statutory reasons. However, do not be afraid. Since you have hired one of the most experienced bankruptcy law firms in the country, your legal helper's attorney will be present with you at this meeting to ensure everything goes smoothly. How soon will my Chapter 7 bankruptcy be completed? During a 60-day time period following the meeting of creditors, creditors listed in the bankruptcy petition may object to specific debts for statutory reasons. Within that time period, the trustee can also move to dismiss the case if he finds that the filing is abusive. These types of objections or abusive filing findings are rare, and oftentimes our attorneys can tell you up front if you may have a problem. Once the 60-day period expires, you will receive your bankruptcy discharge. The total amount of time for your bankruptcy discharge is usually around 3.5 months after your petition is filed. So don't wait to contact legal helpers. Eliminating your bills is easier than you think and typically can happen very quickly. If you're ready to stop the harassment from creditors and take advantage of the fresh start bankruptcy affords you, you can use our secure and confidential online free legal evaluation form to schedule a no-obligation consultation with one of our bankruptcy attorneys, or pick up the phone right now and call our toll-free number, 1-888-743-5787, to speak with legal helpers immediately.